Good morning, ladies and gentlemen. This is an open meeting on the 17th of September, 2025 of the United States Securities and Exchange Commission under the Government and the Sunshine Act. Today, the Commission will consider three recommendations. So first up is the Division of Investment Management. So turn it over to Brian.
Thank you, Chairman Atkins. I'll try again. Thank you, Chairman Atkins and Commissioners Peirce, Crenshaw, and Ueda. The Division of Investment Management recommends further extending the compliance dates for the amendments to Form PF that the SEC and the Commodity Futures Trading Commission jointly adopted on February 8, 2024. Specifically, we recommend extending the compliance date for these amendments by 1 year to October 1st, 2026. When the SEC and the CFTC last extended the compliance date for these Form PF amendments, the commissions recognized that further review may be necessary to determine if these amendments raise substantial questions of fact, law, or policy, all as directed us by President Trump in his January 20th presidential memorandum. Now, having begun that review, I do believe it is important to grant a further compliance date extension to October 1st, 2026, both to provide us necessary time to complete that review and to take any resulting actions, including potentially proposing further amendments to Form PF. To that end, we look forward to continued constructive engagement with both the Form PF filers to inform that review and the end users of that Form PF data to complement our discussions as we strive to make sure that this form is both right-sized and fit for its statutory purpose. In that work, I would like to thank our colleagues at the CFTC, as well as our team here at the SEC, including those from the Division of Economic and Risk Analysis, the Office of the General Counsel, and of course my colleagues on the staff of the Division of Investment Management for all of their hard work on this extension. Now I will turn it over to Dr. Robert Fisher, Acting Director of the Division of Economic and Risk Analysis, who will explain the economic effects of this recommendation.
Good morning, Chairman Atkins and Commissioners. Today, the Commission is considering adopting the extension of the compliance date for the final Form PF. The final Form PF requires private fund advisors to provide enhanced information to the Commission. The extension under consideration today would grant a further compliance date extension to October 1, 2026. The extension will provide additional time for the Commission to complete a review in accordance with the January 2025 presidential memorandum and take appropriate actions if needed. Regardless of whether the Commission determines to amend the final Form PF following the review, the delayed compliance date will save the affected advisors the incremental costs of complying with final Form PF during the 1-year extension. The costs of extending the compliance date are related to the Commission receiving the new information on the final Form PF later. The extension would delay the realization of the economic benefits from the new information on the final Form PF. For example, to the extent that there are significant market events during the extension period, extending the compliance date may result in foregone benefits from the Commission not receiving data from final Form PF. In closing, I want to thank my colleagues in the Division of Investment Management and the Office of General Counsel, with whom we have worked closely during the development of this extension.
Well, thank you. I just, sorry, you have further? Okay, so I just wanted to highlight a few matters too on this particular thing. So, so thanks for your points. And of course, the Commodity Futures Trading Commission will also be considering this joint extension, and and we'll be meeting in a few days. So, as you all noted, that Form PF is a mechanism by which covered private funds confidentially report portfolio investment exposures and risk information about private funds that they advise to the Commission, and if they are also registered as a commodity pool operator or commodity trading advisor to the CFTC. So we provide Form PF data to the Financial Stability Oversight Council to enable it to assess systemic risk, and as part of that process, to better understand market developments and to respond more effectively in periods of stress or crisis. The commissions, both SEC and CFTC, therefore, do not just collect this information to fulfill our respective regulatory mandates. In 2024, the commissions adopted amendments to Form PF that modified questions to provide FSOC with, for example, metrics on new private fund investment strategies, such as credit funds, which were not a distinct asset class when the original Form PF was adopted back in 2010, as well as more granular information from hedge fund advisors on investment and counterparty exposures. The initial compliance date of these amendments was the 12th of March, 2025, which we extended to June 12th, and then to October 1st, 2025, to address transitional challenges brought to our attention by market participants. On January 20th, as you all, the staff just noted, President Trump signed a presidential memorandum directing the agencies to consider postponing for up to 60 days from the date of the memorandum the effective date of rules that had not yet taken effect for the purpose of reviewing any questions of fact, law, and policy that they may raise. And second, to consider further delaying or taking other actions to further delay beyond 60 days where necessary to continue to review these questions of fact, law, and policy. And then finally, where warranted, to provide notice and take further appropriate action. So to provide time for both commissions to complete their review in accordance with this presidential memorandum, we're considering granting this further compliance date extension to October 1st of next year. And to the extent that there are substantial questions of fact, law, and policy, take any further appropriate actions, which may include proposing new amendments to Form PF. At the SEC, for example, I've directed the Division of Investment Management to consider whether we can reduce the number of advisors required to file the form without meaningfully reducing the key risk and exposure information needed by the commissions and by other FSOC member agencies. So anyway, I look forward to reviewing these recommendations and receiving the public's thoughts and comments on any proposals that the commissions may advance. We also look forward to working with the CFTC on this process and consulting with our FSOC counterparts. I appreciate all the work of the staff in all divisions there, IM and the General Counsel's Office and DERA. And I also want to give a special shout out to David Marcinkus of my office, who has been working on it and whose last day will be Friday, the 19th of September. So he's been at the commission 12 years altogether in 2 stints, and so maybe the third time back will be a charm. I'm sort of experienced at that, so good luck in your future endeavors. Dave's a 40 Act expert, and we'll miss his expertise in my office. So with that, let me turn it over to the commissioners for their statements and comments.
Thank you, Mr. Chairman. Thanks, Brian and Rob, for your presentations. And Brian, congratulations on your first open meeting. I support extending the compliance date as planned to October 1, 2026. I welcome today's action as evidence of a commitment to conduct a substantive review of Form PF, and if there are substantial questions of fact, law, and policy, to take further appropriate actions. And those actions could include proposing new amendments to Form PF. I would have preferred a longer extension to better accommodate a fundamental rethinking of the form to ensure its consistency with law and rationality. As I noted in my dissent to the adoption of the amendments that we're extending today, Form PF has not so subtly morphed into an all-purpose means to gather information from the private market under the seemingly limitless rubric of systemic risk. Through Form PF, the commissions send private funds on a scavenger hunt for an odd collection of data, some quite sensitive data points, some requiring extensive work and expense by funds to assemble, and many of questionable relevance to systemic risk or investor protection objectives. The utility of the data to the Financial Stability Oversight Council has never been clear to me. A vigorously competitive market is the best guard against stupid, harmful, and careless behavior by private funds, and costly regulatory mandates like Form PF deter competition. Regulators might sift through Form PF information dumps to detect emerging systemic risks, but a few key data points would probably be more useful indicators of systemic risk. Moreover, the less confidential information that we collect, the less we have to protect. I want to thank the CFTC, SEC staff in IM, DERA, and GC for your quick work on this. And I do just have one question, which is why aren't we delaying this for longer?
Well, thank you, Commissioner, and as always, we look forward to working with you and your office on this to the extent we go forward with any recommendations. We very much value your thoughtful interaction on all these points, and we look forward to that. But to your specific question, why aren't we doing it any longer? We think a year is enough. We think that given the mandate we have in front of us, given the amount of thought that's gone into it, even before my coming here, we think a year is sufficient. If it turns out that we are wrong and I have egg on my face in 12 months and we're here, you can remind me of that. And but at the moment, we are very comfortable with that number.
Sounds good. Thank you. I don't have any additional questions.
So here we are again. I can't say I'm surprised that we are back for yet another compliance date extension for Form PF. Just 3 months after our last vote on the exact same issue. We clearly have not been dissuaded from our desire to slowly but surely extinguish duly adopted amendments to Form PF via extension after extension after extension, despite the command of the Administrative Procedure Act to engage in transparent notice and comment rulemaking when rescinding rules. And while I'm not surprised we're back, I am surprised by our repeated flouting of the APA. So, unsurprisingly, I cannot support yet another extension. With its third and longest extension to date, the Commission finally comes clean. Today's release suggests that we are delaying the recent amendments, collectively final Form PF, yet again to buy ourselves more time to write them out of existence before they ever go into effect. In other words, it seems we are delaying them indefinitely and as long as it takes to undo them. This is a thinly veiled sleight of hand to dismantle the work of a prior commission while weaseling out of the clear requirements of well-established law. First, there is clear judicial precedent holding that an indefinite extension of a duly adopted rule is not permitted. In the past, courts have recognized sudden reversals of agency action without notice and comment under the APA as a danger signal. In the absence of the APA process, courts fear that an agency may undo what it has accomplished through rulemaking without giving the public an opportunity to comment on the prospect of repealing that work. Recognizing that there is a heightened risk of an APA violation in these circumstances, courts have required close scrutiny of such actions. Courts have applied this heightened analysis to the effective dates of agency action specifically. The Third Circuit, in fact, has been asked the exact question I had before today's meeting. Quote, may an agency promulgating a rule postpone it indefinitely without subjecting that indefinite postponement to the notice and comment procedures of the APA? End quote. In short, the court's answer was no. The court held that the APA could not be read to allow for an indefinite extensions of a rule's effective date because such a reading would permit an agency to, albeit indirectly, repeal a rule simply by eliminating or indefinitely postponing its effective date. We know it's not unheard of for the Commission to extend compliance dates for a short, set amount of time to allow registrants more runway to prepare for new rules. But that is not what we endeavor to do today. With multiple extension requests for longer and longer time periods, we convey our clear intent to indefinitely delay the compliance date of the final form. We also fail, yet again, to seek public comment on a potential path forward, further demonstrating our willingness to conduct Commission action without public input. This approach calls into question the legitimacy of each of these Commission actions and defies clear directives from the APA and the courts. It's also deeply troubling that we do not acknowledge any of this directly relevant precedent in today's release, or in either of the two previous Form PF extension releases. perhaps we know that we cannot legally justify these extensions, and so we aren't even going to try. I worry about ignoring the courts in the same way that we ignore compliance dates for final Form PF. Second, the release fails to show good cause that might otherwise justify our decision to forego notice and comment rulemaking. While the APA generally requires notice and comment rulemaking, an agency may proceed without notice and comment when it finds, for good cause, that notice and public procedure are impracticable, unnecessary, or contrary to the public interest. Good cause is meant to be a high bar. Courts have cautioned that this exception must be narrowly construed to avoid creating an untenably large loophole in the APA. This exception is not designed to accommodate cyclical changes in the composition of the Commission and shifting policy goals. Certainly, in rare circumstances, good cause can exist. But the release doesn't even really try to argue that the standard is met here. It simply refers back to the same arguments we've been parroting for the last two extensions regarding a presidential memorandum and supposed compliance challenges. But the courts have also held that EOs do not necessarily constitute good cause in this context. Our inability to provide a detailed justification is telling. Here again, the release declines to engage in any legal analysis of precedent and simply cites to a few industry letters as our justification for another extension. But it's clear these claims are being furnished to cover further delay to the final form. Interestingly, it seems that a few of the letters cited as support for these claims in the release are not even publicly available. This is a far cry from how our rulemaking process is meant to function. There's a reason courts have forbidden this type of behavior. This approach erodes duly adopted Commission rulemakings. It erodes the rule of law. Continuity and certainty are beneficial to registrants, investors, and the stability of markets at large. When the Commission adopts a rule, the investing public and other market participants should be able to rely on that rule as the law, until the Commission engages in transparent notice and comment rulemaking to engage, to change, or repeal those rules. In fact, the Eighth Circuit just reiterated this to us, noting it is the agency's responsibility to determine whether its final rules will be rescinded, repealed, modified, or defended. The right thing to do would be to allow the new format to go into effect and then, in time, engage in notice and comment rulemaking to repeal the amendments if this Commission so desires. Instead, we're creating a new normal where the APA is optional and final rules are only final when we feel like it. The outcome of today's vote is significant, well beyond the impacts to final Form PF. Today's vote signals that we are willing to repeatedly bend, or in this case extend, the rules until they break. Even though I'm unable to support today's release, I am grateful to the staff in the Division of Investment Management, the Division of Economic and Risk Analysis, and the Division of the General Counsel for their work on this release. Congrats also to Dave Marcinkus, and best of luck to you in the future. Thank you.
Well,
thank you, Chairman Atkins, and thank you to the staff for your presentation. Today, the Commission, in coordination with the Commodity Futures Trading Commission, is extending the compliance date for the February 2024 amendments to Form PF. This decision reflects a necessary response to evolving legal, policy, and practical considerations. On January 20th of this year, President Trump directed federal agencies to review regulations that had been finalized but not yet taken effect. In response, the SEC and the CFTC initiated a review of the Form PF amendments to determine whether they raise substantial questions of fact, law, or policy. And this review is ongoing, and it reflects our obligation to ensure that regulatory actions are consistent with the administration's priorities and legal framework. Since the extension was granted earlier this year, we have received additional feedback from market participants expressing concerns about the final Form PF amendments. These concerns are not merely procedural. They raise significant questions on whether the amendments are workable, necessary, and in certain cases, authorized by law. Moreover, because of changes made in the final rule from the proposal, some questions were not addressed at all during the original rulemaking. The Commission rightfully should take the time needed to address and evaluate these issues. Requiring compliance with a rule that is under active review risks imposing unnecessary and potentially duplicative costs that are ultimately borne by investors. Private fund advisors would be forced to invest in systems and processes that may ultimately need to be revised or abandoned if the rule is modified or rescinded. And these costs are often expressly and explicitly passed on to fund investors as an expense of the fund. Just take a look at some of the limited partnership agreements, which clearly state that Form PF compliance costs are a fund expense and not to be taken out of the management fee. Well, this simply is not a responsible approach to regulation. Now, by extending the compliance date, we are potentially avoiding wasteful efforts while the Commission completes its review. Good regulation balances the benefits of information collection with the burdens imposed on those who must comply. The February 2024 amendments to Form PF raised serious questions about whether that balance has been achieved. Today's extension for a definitive 12-month period, not indefinite, is a prudent step that reflects our commitment to a thoughtful, transparent, and effective rulemaking. I thank the staff of the Division of Investment Management and the Division of Economic Risk and Analysis and the Office of the General Counsel for their continued work on this matter. I also want to give a big thank you to the efforts of our colleagues at the CFTC, including Acting Chairman Pham, on this issue. I look forward to engagement with market participants as well as our counterparts over at the Department of the Treasury, the Office of Financial Research, and others who are the intended users of this data regarding Form PF. Thank you. I don't have any questions, but I did want to give a shout out to David Marcinkus. I was very happy at the beginning of this year when I started as the acting chairman that you accepted an offer to come up and work in the chairman's office, and I've been very, very appreciative of your guidance and your advice during the time and how you've continued to play that role for Chairman Atkins. So I wish you the best in your next professional endeavor. No questions for the staff.
Okay, thank you. I did have a couple of follow-up points for Mr. Daly. So as far as the postponing of this, is it an indefinite postponing?
No, it's for 12 months.
Okay. So, I guess, your response to Commissioner Peirce about, the work that's been done already. So you think that a year's time is, I would say, probably more than enough? Is that putting words in your mouth, or what's your view of that?
No, I think I said something to that effect already. And just to put it into context, when I came on board about 9.5 weeks ago, we did make this a priority right away. And because we did have a deadline hanging over our heads, we did have significant issues to think about. And so working through these was something that we did as a group in investment management. We mobilized an entire team, taking comments, looking at the form. So I think we've done a lot of the legwork already to give us a jump on moving forward. And I do think a year is enough time.
Right. So the people that, the various agencies that use this information, because this, after all, this form is for information that's basically is of, by, and for the government. It's not really for public consumption. Is that correct?
That is right. And again, there is a misconception out there that this is an SEC form and an SEC form only. First of all, obviously, it's a joint form with the CFTC. And second, we are the collection point for this information, but in many ways, the prime users are FSOC and the other FSOC members who have responsibilities for, among other things, ensuring that Treasury bond auctions go off accurately or go off effectively.
Right. Well, so when I came aboard, I haven't been at the commission, when we've had this form. This form came, after Dodd-Frank. And at the time, once the original one was promulgated, I thought it was way, in detail and, pretty much, surprising amount of information that was there. And I remember at one conference that I participated in, then Chairman Shapiro basically said, well, we know this is a lot of information that we're asking for, and something to the effect that, if we are collecting too much, that we will be able to ratchet it back in the future. So we're in the future, and so obviously this is new to me at the commission here. And how about the other agencies that use this? I mean, the CFTC is not, will have new people, is that right? And then the other agencies, so the Fed, we have a new vice chairman of supervision there who just got in, and then the controller of the currency maybe, and obviously a new Treasury secretary. So all of those people, we've been talking to them, right, about all of this?
We've certainly begun our outreach. We have not hit every single person that you have listed, but we expect to continue that as we go through over the next coming days and months and weeks. Days, weeks, and months.
Right, okay. And the other people that might be, so Dr. Fisher, the other people who might be interested in this are where? Other economists around the government, at the Fed, Council of Economic Advisors, who has access to this?
I turn for OGC and IM to answer who has access, but certainly if there was a crisis, there would be of some sort. There would be information aggregated and shared to all the important parties, and it would include them. As to whether they have direct access, I don't know the legal answer to that.
Yeah, so FSOC has access to it under an MOU. We also have MOUs where we directly share it under the confidentiality protections there with the Federal Reserve Board and the CFTC, but through the FSOC, and FSOC itself has an MOU, so that allows FSOC members to gain the information that they need from Form PF.
Well, and then Ms. Sitoff, you were obviously here involved before, and neither Mr. Daly nor I were, but as far as touching base with others, as we go through this, is that an easy process to do? Do we get good feedback from them as to, whether they think, we're on the right track or not?
I'm hesitant to talk too much in an open forum about what other government agencies have told us, but we're happy to brief you on that, and we have had, I think, very fruitful discussions with a number of our SOC partners.
Yeah, I just mean that just the process of touching base takes time, and I've done a little bit of that with my counterparts, but it's not a quick and easy thing.
No, I mean, we have absolutely done that over the years. We've gained lots of good information from them, and yes, that is something that evolves over time, and we continue to talk to them and collaborate.
Right. So again, these are all new people in their jobs and taking a fresh look at things, including the president who has directed us, and he's obviously new since the 21st of January. So I think we have a lot of participants, and we want to make sure that everybody's on board, and so that's going to be part of the process. And then as far as any other, the public, again, is not really involved in this information. It's confidential and all of that. So it's carefully husbanded, I assume, by us and by our counterparts. So I, for one, certainly want to make sure that if we're demanding information from people, that it's not excessive and not excessive costs. We've seen with the consolidated audit trail, swaps reporting, and so many other things, how excessive information has huge costs and also distractions, frankly, from what is actually useful, what's wheat, what's chaff, and whatnot. So I think it's incumbent on us to be careful as we go through this.
Yes, Mr. Chairman. And I think that comes in two ways. I think you said it earlier. You're directing us to both look at the scope of reporters and whether there can be some reduction there, and the scope of the questions asked and whether we could do some reduction there. And we will be looking at both of those tracks simultaneously.
Great. Okay. Yep. So as the old saying goes, measure twice, cut once, and let's not make a mistake. So anyway, we're in good hands with you all, working on this here over the next few months, and I look forward to your recommendations when you come back. So any other points?
Just want to add my thanks to David Marcinkus and congratulations.
Lots of encomiums for Mr. Marcinkus. Okay, that's great. No further points. So do the commissioners vote to approve the Division of Investment Management's recommendation to extend the compliance date to the 1st of October 2026 for the amendments to Form PF that were adopted on February 8th, 2024?
Yes.
No.
Yes.
And yes. Thank you all very much. So I guess I need to announce the vote for the Secretary's purpose. The recommendation is approved by a vote of 3-1. Okay. You can count too, right? All right. Well, so the second and third recommendations on today's agenda will be presented together by the commission staff and discussed at the same time among the commissioners, and then each item will be voted separately. So the second item on today's agenda is a recommendation that the commission issue a policy statement addressing the presence of a mandatory arbitration provision in the governance documents of a company registering offers and sales of securities and its impact on the acceleration of the effectiveness of the registration statement. In this context, a mandatory arbitration provision requires an investor to arbitrate its claims arising under the federal securities laws with the issuer of the securities. So there are two separate questions with respect to mandatory arbitration. First, what is the state of the law on the permissibility of mandatory arbitration provisions? And second, assuming such provisions are allowed, should a company adopt mandatory arbitration? The answer to the first question sits at the intersection of the federal securities laws, state corporate law, and the Federal Arbitration Act of 1925. The expertise and domain of the Commission and its staff is, of course, in the federal securities laws. Accordingly, the policy statement provides the Commission's views on whether mandatory arbitration provisions are inconsistent with the federal securities laws, and it concludes that they are not. While I am pleased that the Commission is voting today on whether to issue this policy statement, I must note that the agency is unfortunately at least a decade too late in taking this action. Over the past 40 years, federal courts, including the Supreme Court, have issued several decisions informing the analysis of whether the federal securities statutes override the Arbitration Act. As the policy statement details and the staff's presentation will highlight, the law in this area has been clear since at least 2013. Despite the abundant judicial decisions on this issue, the Commission has not publicly shared its views on this topic since an amicus brief it submitted back in 1986. The agency has, however, scrutinized registration statements filed by companies that have sought to include a mandatory arbitration provision in their governance documents and injected uncertainty into whether these registration statements would be declared effective. Companies contemplating an IPO today may interpret these prior actions to reflect the Commission's current views on the issue. As an agency that trumpets the importance of disclosure and transparency, the Commission's lack of a recent public position on this important topic is unmoored from both its mission and its mandate. However, that ends today if the Commission approves this public statement, policy statement. Of course, when analyzing whether mandatory arbitration provisions are valid, companies must also consider state corporate law. This issue has become more crucial in light of Delaware's recent amendments, which became effective just last month to its general corporation law that may prohibit a company's governance documents from including a mandatory arbitration provision. Other states may take different approaches. Neither the Commission nor its staff has the expertise to address a provision's enforceability under state law and any preemption concerns raised by the Arbitration Act with respect to state law. Regardless of the validity of mandatory arbitration under state corporate law, the policy statement provides companies with the clarity that the presence of a mandatory arbitration provision will not impact decisions regarding whether to accelerate the effectiveness of a registration statement. Now, turning to the second question, with clarity under the federal securities laws and assuming validity under state corporate law, should a company adopt a mandatory arbitration provision? I expect there to be a robust public debate on this issue among various interested parties. I have views on this issue, and I'm sure that my fellow commissioners do as well. However, the Commission as a body will not be part of this debate because it is outside the scope of matters over which the Commission has authority under the federal securities laws. The Commission's statutory criteria in deciding whether to accelerate the effectiveness of a registration statement is to ensure complete and adequate disclosure of material information to the public. In other words, the Commission is not a merit regulator that decides whether a company's particular method of resolving disputes with its shareholders is good or is bad. Consistent with this directive, the Commission should not participate in a debate on whether mandatory arbitration provisions are good or bad for their companies and their shareholders. Rather, the Commission and its staff should focus on ensuring complete and adequate disclosure of material information that is meaningful to a reasonable investor by the objective standards set forth by the Supreme Court concerning a company's mandatory arbitration provision, if one exists. This approach is in keeping with how the agency has treated certain other provisions that companies impose for resolving disputes, such as exclusive foreign requirements for Securities Act claims. While many people express views on whether a company should adopt a mandatory arbitration provision, the Commission's role in this debate is to provide clarity that such provisions are not inconsistent with the federal securities laws. It will fulfill that role through the issuance of today's policy statement. So then, with respect to amendments to Rule 431 of the Commission's Rules of Practice, just a couple of points to make. In connection with the Commission's vote on that statement, the Commission will also vote on these rules of practice, and this is the third item of today's agenda. This rule governs the Commission's review of actions made pursuant to authority granted to the staff. Since 1963, the Commission has delegated to the Director of the Division of Corporation Finance its authority to accelerate the effectiveness of a registration statement filed under the Securities Act. I remember back in 2002 when I was confirmed as a commissioner, a former commissioner who served in the 1970s called to wish me the best, and one piece of advice that he gave me was not to spend a lot of my time reviewing registration statements as he had done. My, how times have changed. Of course, this delegation to the staff is a practical necessity, as the Commission cannot possibly vote on the thousands of acceleration requests submitted each year. This is particularly the case with respect to market-sensitive transactions, where the Commission's delegation of authority to its staff to declare registration statements effective plays a critical role in the agency's ability to move with alacrity on behalf of issuers and investors. When the Commission acts via delegated authority, any individual commissioner or any aggrieved person may ask the Commission to review that action. Subject to limited exceptions, a request for review stays the prior action taken by delegated authority until the Commission orders otherwise. Currently, declaring a registration effective is not among the exceptions to a stay. However, stays of an effective registration statement may be extremely disruptive. A company, its underwriters, and other market participants may commence sales of the securities once the registration statement is effective. A stay of effectiveness, on the other hand, could fundamentally interrupt the sales process. Investors, selling security holders, as well as purchasers might be extremely disadvantaged, to say the least. Market participants could incur costs as a result. A stay could also create uncertainty for issuers and underwriters that have sold securities. Rather than automatically trigger such adverse consequences, the Commission should take the opportunity to carefully weigh the equities involved before taking such a significant step. Adding declarations of effectiveness of registration statements to the limited list of exceptions to the automatic stay requirement will help to alleviate some of the aforementioned concerns. In the execution of its mission, the Commission should provide as much regulatory certainty as possible to market participants raising capital. Today's amendments to Rule 431, I think, further that mission. Today's recommendations on mandatory arbitration and Rule 431 are among the first steps of my goal to make IPOs great again. This ambitious project will make being a public company an attractive proposition for more firms by eliminating compliance requirements that yield no meaningful investor protections, minimizing regulatory uncertainty, and reducing legal complexities throughout the SEC's rulebook. The next steps in this project include enhancing accommodations for newly public and private and smaller companies, expanding post-IPO companies' ability to easily access the public markets to raise additional capital, simplifying disclosure requirements for executive compensation and other topics to focus on material information, and finally, modernizing the shareholder proposal process. So I thank President Trump for his idea of semi-annual reporting by public companies that he posted the other day on social media. The staff is currently preparing recommendations for each of these topics, and I eagerly await the Commission's proposal for each recommendation. So before I turn the meeting over to Cicely Lamoth, Acting Director of the Division of Corporation Finance, to discuss the recommendations, I should note that Cicely will soon turn over her acting director duties to a more permanent director. As acting director, Cicely has done an extraordinarily wonderful job to keep the operations of the Division of Corporation Finance running smoothly, in addition to continuing to execute her quote-unquote regular responsibilities, doing double time there, as deputy director of the Disclosure Review Program. So she's helped to make my coming aboard as chairman and my transition into this job a real delight. She and her staff have been very forward-thinking and creative in their advice to me. Cicely, I very much look forward to our continued collaboration in your very challenging role as Deputy Director, for which you are very well suited and have distinguished yourself very much. So today's recommendation on the policy statement and amendments to Rule 431 could not have been accomplished without the exceptional work of the following staff members. From the Division of Economic and Risk Analysis, Robert Fisher, Oliver Richard, Lyndon Orton, Angela Huang, Lauren Moore, Charles Woodworth, and Andrew Glickman, who, by the way, is leaving the commission here, and I salute him for his long service with us. From the Office of General Counsel, Jeffrey Fennell, Bryant Morris, Dorothy McQuaig, Brooks Sherry, Evan Jacobson, Michael Killoy, and Eduardo Aleman. From the Division of Investment Management, Brian Daly, Anna Sandnor, Yoon Chu, Andrea Otomelli McGovern, Matthew Cook, and Jaya Han. And finally, from the Division of Corporation Finance, Cicely Lamoth, Sebastian Gomez Abero, Michael Seaman, Jonathan Ingram, Adam Turk, Anna Abramson, Jessica Ansart, and John Fieldson. So now I turn it over to Cicely for the staff's recommendations.
Thank you, Chairman Atkins and Commissioners, and thank you for those kind words. Today, we are recommending two matters for the Commission. First, we are recommending that the Commission issue a policy statement relating to the acceleration of effectiveness of registration statements of issuers with certain mandatory arbitration provisions. Second, we are recommending the Commission amend its rules of practice relating to certain procedures governing Commission review of staff actions made pursuant to delegated authority. The policy statement, the first of our recommendations today, would inform the public that the presence of a mandatory arbitration provision for investor claims arising under the federal securities law would not impact decisions regarding whether to accelerate the effectiveness of a registration statement. The policy statement does discuss several developments that inform our recommendation, including the U.S. Supreme Court's evolving interpretation and application of the Federal Arbitration Act of 1925. The Commission has not spoken publicly on this specific topic, even though during the registration process, issuers on occasion have sought to include mandatory arbitration provisions in their Securities Act registration statements. The amendments to the Commission's rules of practice is the Division's other recommendation today, and it would expand the list of actions for which there would be no automatic stay while a delegated staff action is being reviewed by the Commission. Under the Commission's current rules of practice, after the staff exercises its delegated authority to accelerate a registration statement or qualify an offering statement under Regulation A, any one member of the Commission may vote to bring the matter before the Commission for review, or any aggrieved person can request that the delegated action be reviewed. Currently, this request results in an automatic stay of the registration statement's effectiveness or an offering statement's qualification. This stay could occur while sales are in progress or after they have already been made. As a result, such an automatic stay would disrupt the sales process, and market participants could experience additional cost and uncertainty. Eliminating this automatic stay, as we are recommending, would provide greater predictability and certainty in the registration and qualification processes. These recommendations we present today are the result of a collaborative effort among a highly dedicated group of talented staff. I would like to thank them for their hard work. The chairman read their names, so I won't repeat them, and I will now hand it over to John Fieldson, who will discuss our recommendations in greater detail. Thank you.
Thank you, Cicely. Good morning, Chairman Atkins, Commissioners. As Cicely just mentioned, today the Division of Corporation Finance is making two separate recommendations for the Commission. The first recommendation is that the Commission issue a policy statement relating to the acceleration of effectiveness of registration statements disclosing certain mandatory arbitration provisions. If adopted, this policy would clarify that the presence of a mandatory arbitration provision for investor claims arising under the federal securities laws, what we will call an issuer-investor mandatory arbitration provision, would not impact decisions regarding whether to accelerate the effectiveness of a registration statement. Accordingly, When deciding whether to accelerate effectiveness, the staff would focus on the adequacy of the registration statement's disclosures, including disclosure regarding the arbitration provision. The second recommendation we are making is for the Commission to amend Rule 431 of its Rules of Practice relating to the procedures governing Commission review of staff action made pursuant to delegated authority in connection with the determination of the effective date of a registration statement and any of its post-effective amendments, and the determination of the date and time of qualification of an offering statement under Regulation A and any of its post-qualification amendments. If the amendments are adopted, those staff actions made pursuant to delegated authority would be excluded from the actions subject to an automatic stay when an aggrieved person files a notice of intention to petition for Commission review, or when there is a vote by one member of the Commission to review the matter until the Commission orders otherwise. More specifically, our recommendations are as follows. With regard to the policy statement, Section 8A of the Securities Act provides that a Securities Act registration statement will become effective automatically 20 calendar days after it is filed. However, Securities Act Rule 473A, among other things, allows an issuer to include a delaying amendment on the front page of the registration statement to extend the registration statement's effective date until the Commission grants the issuer's request to accelerate that effective date. The staff, acting pursuant to its delegated authority, will accelerate the effective date if the criteria under Section 8A and Rule 461 are met. These criteria are primarily focused on ensuring complete and adequate disclosure of material information to the public and require consideration of the public interest and the protection of investors. During the registration process, issuers have periodically asked whether the presence of an issuer-investor mandatory arbitration provision would impact the acceleration of the effectiveness of their registration statement. There have been several developments involving the Supreme Court's interpretation and application of the Federal Arbitration Act, or FAA, that inform such acceleration requests. In addition, potential uncertainty exists regarding the intersection of the FAA and state law. Notwithstanding these developments and potential uncertainty, the Commission has not spoken publicly on this topic. The FAA establishes a federal policy of favoring the enforceability of arbitration agreements. In the past, the federal security statutes were thought to potentially override the FAA because issuer-investor mandatory arbitration provisions could be viewed as inconsistent with the federal security statutes in at least two respects. First, these provisions could violate the anti-waiver provisions of the federal security statutes by foreclosing a judicial forum. And second, these provisions could unduly impede the ability of investors to bring private actions to vindicate their rights under the federal securities laws by foreclosing class action litigation in courts. Nevertheless, two Supreme Court decisions in the late 1980s held that the federal securities laws' anti-waiver provisions apply to the substantive obligations under the Exchange Act and the Securities Act, and do not preclude enforcement of arbitration agreements, which instead address jurisdictional issues. Both of these decisions, Shearson American Express v. McMahon in 1987 and Rodriguez v. Shearson American Express in 1989, involved arbitration agreements between a brokerage firm and its customers. Although these two Supreme Court decisions did not involve the precise issue of issuer-investor mandatory arbitration provisions, they were both grounded on, among other things, that federal policy strongly favors enforcement of arbitration agreements and that arbitration itself is a suitable means for resolving the kinds of commercial disputes arising under the federal securities laws. Accordingly, we see no reason to believe that any different result should follow in the context of issuer-investor mandatory arbitration provisions. Fast forward 2 more decades, and the Supreme Court's decision in American Express v. Italian Colors in 2013 clarified that the FAA is not displaced merely because bilateral arbitration may undermine the economic incentive of some persons to bring private federal securities law claims. In fact, the potential for issuer-investor mandatory arbitration provisions to diminish or even eliminate the economic incentive is not part of the consideration of the criteria to accelerate the effectiveness of a registration statement, a criteria that, as I mentioned earlier, is primarily focused on ensuring complete and adequate disclosure of material information to the public and requires consideration of the public interest and investor protection. In the Italian Colors case the Italian colors case involved arbitration of the federal antitrust statutes. But based on similarities between those statutes and the federal securities laws, we conclude that the potential for issuer-investor mandatory arbitration provisions to diminish or even eliminate the economic incentive for some investors to bring private claims under the federal securities laws is not a sufficient basis to determine that the federal securities statutes displace the FAA's policy favoring arbitration. In a subsequent decision in 2018, in Epic Systems v. Lewis, the Supreme Court noted that in any federal statute enacted after the FAA, which would include all the federal security statutes, there must be a clearly expressed congressional intention to override the FAA. The court explained that when Congress does not displace the FAA using unambiguous statutory language, there is a strong presumption that the FAA applies exclusively to any issues regarding the enforceability of the arbitration agreement, and the other federal statutes that give rise to the underlying substantive claims have no relevance to the enforceability of the arbitration agreement. In light of the Supreme Court's jurisprudence relating to the FAA and other case law involving the intersection of the FAA and federal statutes, this policy statement concludes that the enforcement of issuer-investor mandatory arbitration provisions is governed by the FAA and not by the federal security statutes. This conclusion follows from the fact that nothing in the text of the anti-waiver provisions or other provisions of the federal security statutes demonstrates a clearly expressed congressional intention to accept issuer-investor mandatory arbitration provisions from the FAA's policy of favoring arbitration. Because the federal security statutes do not override the FAA when it applies to issuer-investor mandatory arbitration provisions, this policy statement concludes that the existence of such a provision is not among the appropriate considerations to be weighed when taking a registration statement effective, and therefore should not impact determinations regarding whether to accelerate the effective date of a registration statement. This policy statement acknowledges that there may be instances in which the FAA does not apply, such as where there is no valid and enforceable written agreement for purposes of the FAA. Given that neither the Commission nor the staff is well positioned to conclusively determine when the FAA applies, and in light of the case law developments discussed earlier, this statement concludes that any relevant issues concerning issuer-investor mandatory arbitration provisions are best addressed through complete and adequate disclosure of material information in the registration statement. This policy statement also makes clear that it should not be understood to express any view on the specific terms of the arbitration provision, or whether arbitration provisions are appropriate or optimal for issuers or investors. Rather, this statement informs the public that the presence of such provisions will not affect decisions to accelerate the effective date of a registration statement. For the next release on today's agenda regarding the rules of practice, Rule 431 of the Commission's Rules of Practice governs the Commission's review of actions made pursuant to delegated authority. Rule 431E provides that an action made pursuant to delegated authority shall have immediate effect and be deemed the action of the Commission. The rule also provides that, upon filing with the Commission a notice of intention to petition the Commission for review by an aggrieved person, or upon the vote of a single member of the Commission that the matter be reviewed, an action made pursuant to delegated authority is automatically stayed until the Commission orders otherwise. The automatic stay, however, does not apply to certain delegated actions specified in Rule 431E. We recommend that the Commission amend its list of delegated staff actions in Rule 431E that are not subject to an automatic stay to include determinations of effectiveness of a registration statement in any of its post-effective amendments, and qualification of an offering statement under Regulation A in any of its post-qualification amendments. As I mentioned earlier regarding our mandatory arbitration recommendation, Section 8A of the Securities Act provides that a Securities Act registration statement will become effective automatically 20 calendar days after it is filed, unless the issuer includes a delaying amendment on the front page of the registration statement, which, again, will extend the registration statement's effective date until the Commission grants the issuer's acceleration request. The staff may act pursuant to its delegated authority to accelerate the effective date if certain criteria are met. Moreover, Regulation A provides an exemption from the Securities Act registration requirements for certain offers and sales of securities. Any issuer relying on Regulation A or the Regulation A exemption, is required to file an offering statement that the Commission must qualify before the issuer may sell securities. As with the registration statement, the Commission has delegated its authority to qualify an offering statement to the staff. Imposing an automatic stay of the staff's acceleration and qualification determinations upon filing of a notice of intent to petition for review, or upon the vote of one commission member that a matter be reviewed, would be unnecessarily disruptive to the registration and qualification processes, particularly if the issuer already relied on staff's determination to begin the sales process. Because of the potential disruptive consequences of an automatic stay in these scenarios, we recommend that the Commission amend Rule 431E to eliminate the automatic stay of delegated actions to accelerate the effectiveness of registration statements and to determine the qualification of offering statements. Doing so would allow the Commission to consider on a case-by-case basis whether to impose a stay based upon, among other appropriate considerations, whether there is a likelihood of inadequate disclosure in the registration or offering statements, and whether the balance of harms from the potential inadequate disclosures is sufficient to justify the imposition of a stay given the potential disruptive consequences that a stay would cause. Thank you very much. I now turn to Dr. Robert Fisher, who will discuss the economic analysis with respect to the amendment regarding the rules of practice.
Today, the Commission is considering amendments to Rule 431 of the Commission's Rules of Practice. These amendments would expand the list of actions for which there will be no automatic stay when a delegated action is reviewed by the Commission. These technical amendments do not impose any substantive regulatory obligations. The amendments, if adopted, are likely to benefit an affected issuer, as well as underwriters, investors, and any selling security holders, by avoiding the costs and uncertainty resulting from an automatic stay in the event that a petition for review is filed. However, the amendments would not preclude an aggrieved party from filing a petition for Commission review of an action taken by delegated authority or a member of the Commission from bringing such an action before the full Commission. In closing, I would like to extend my sincerest thanks to my colleagues in the Division of Corporation Finance and the Office of General Counsel. Thank you, and we are happy to answer any questions.
Well, thank you very much. Let me turn it over to Commissioner Peirce.
Thank you, Mr. Chairman. Thank you to Cicely and John and Rob. And I want to thank the staff in the Division of Corporation Finance, Division of Investment Management, Division of Economic and Risk Analysis, and Office of General Counsel for your work on these items. Cicely, I want to take a moment to thank you also for your leadership of the division. Working with you has been a delight in that capacity, and I'm glad we'll have a chance to continue to work together. You promote others rather than yourself, and you follow through on what you say. Your no-nonsense leadership style has enabled the division during a period of transition to be very productive. You don't shy away from hard problems. You just solve them sensibly, and I think today's actions exemplify this approach. First, the Commission is acknowledging the limits of our authority. The presence of a provision requiring arbitration of investor claims arising under the federal securities laws will not factor into the SEC's decision about whether to accelerate the effectiveness of a registration statement. This position is not an invention of the Commission, but rather an acknowledgement of current Supreme Court precedent. Knowing that the SEC will not put its thumb on the scale, companies can decide whether they want to include arbitration provisions. A common consideration for any company contemplating going public is the litigation risk that comes from being a public company. Past signaling from the SEC, unrooted in any apparent statutory authority that it would block the registration statements for companies with arbitration clauses, prevented companies from taking a step that some viewed to be value maximizing and thus good for their shareholders. Whether those companies are correct should be up to the market to decide. If companies opt for mandatory arbitration clauses, investors can decide what to make of them. The costs and benefits of issuer-investor mandatory arbitration provisions spark lively debate. The Commission, by today's action, appropriately is staying out of that debate. The market will do a better job than we can in assessing those arbitration provisions, and will do so on a case-by-case basis. This statement empowers investors to decide for themselves whether the presence or absence of a mandatory arbitration provision is positive, negative, or neutral. Investors' judgments will be reflected in companies' stock prices and in the general demand for allocation in an IPO. Today, we're also providing certainty to companies by making common sense changes to our rules of practice. Every day, Commission staff, by delegated authority, take effective registration statements and qualify offering statements. Were a registration to be stayed after effectiveness, a company would experience a cavalcade of horribles: impaired access to capital, less favorable financial terms, and a legal morass as the company tries to untangle what it means to have sold securities pursuant to an effective but subsequently stayed registration statement. Instead, the Commission is adopting a tailored approach that allows us to consider on a case-by-case basis whether a stay is justified while removing unnecessary risk from the IPO process. Where the SEC can remove needless uncertainty from an offering process, it should. I'm glad to see the Commission address the sluggish IPO market from all possible angles. I have a couple questions. First, how does the staff assess the sufficiency of disclosure regarding issuer investor mandatory arbitration provisions when considering taking a registration statement effective?
Thank you for your question, Commissioner Peirce. I'll take that one. So in deciding whether to exercise our delegated authority to declare a registration statement effective, the staff assesses whether complete and adequate disclosure of material information has been provided. If an issuer were to include a mandatory arbitration provision, we would consider whether those disclosures may be material given the particular facts and circumstances. So that could include, for example, a disclosure describing the provision, material risk of the provision, as well as if there are material impacts to shareholders based on the terms of the provisions, uncertainty regarding enforceability, as well as impact on claims arising from other laws. So I think that that's consistent with the approach that we take normally when we are assessing disclosure for registration statements that we're contemplating acceleration.
That's helpful, thank you. And then under what circumstances might a registration statement be stayed after it goes effective? We're just saying there's no automatic stay in the circumstances of someone pulling it up for review, but are there any circumstances where a stay could still happen?
Yes, thank you for that question, and that is correct. There are still situations where the Commission could deliberate and choose to impose a stay. I will defer to my colleagues in OGC who can probably clarify the process a little bit clearer.
Absolutely. Thank you, Commissioner Peirce. The Commission does have pretty broad discretion to put in place a stay if it wishes to do so while it's reviewing the staff action. One reason it may wish to do so is if petitioner or commissioners identified a potential concern with the disclosure in the registration statement. That would be a basis for putting a stay in place while the Commission reviews the staff action.
Thank you. I don't have any additional questions.
Mr. Crenshaw.
Good morning. We still morning? Yeah, I think so. All right. Before I begin, I do want to thank the staff in the Division of Corporation Finance, the Office of the General Counsel, Division of Economic and Risk Analysis, and the Division of Investment Management as well for their work. I also want to thank Operations and IT who helped make today's meeting possible. I would also like to thank Cicely Lamoth for her service as Acting Director. For those of you who don't know Cicely, she is a public servant in the best sense of the word. She is dedicated, hardworking, thoughtful, and committed to her staff and the public good. And she does it all with a smile and an unflappable composure. She has taken on this very large task, probably for longer than she anticipated, and for that we are grateful. Thank you, Cicely. Today, the Commission finds another way to stack the deck against investors. This time, primarily small retail investors in public companies. We do so by opening the floodgates to something called mandatory arbitration. So what is mandatory arbitration? Mandatory arbitration forces harmed shareholders to sue companies in a private, confidential forum instead of a court, and without the benefit of proceeding in the form of a class action. While, in theory, arbitration could cut costs for companies, there are real downsides for investors. Arbitrations are typically more expensive for individual shareholders. They are not public. They have no juries. They lack consistent procedures. Arbitrators are not bound by legal precedent. Arbitration precludes collective action among shareholders. There are limited rights of appeal. And ultimately, there is no assurance that two identical investors would get the same outcome. If that collection of things transpired in a courtroom without a party's consent, judges would not hesitate to call it what it is, a violation of due process. Today, the Commission takes 2 steps to advance this policy goal. First, the Commission issues a policy statement dictating that staff make a public interest finding without considering whether a corporation has forced its shareholders into mandatory arbitration. And second, we amend the rules of practice to ensure that no commissioner or third party can effectively intervene to challenge those public interest findings. The policy statement fails on many fronts. It fails to identify a problem. It fails to adequately address numerous and complex legal and economic issues. And it fails entirely to discuss the practical consequences of allowing public companies to mandate arbitration. If, however, we actually were to consider whether mandatory arbitration is in the public interest, an analysis required by the Securities Act, we would face overwhelming evidence that it is not. So, to start there, what are some of those consequences? First, shareholders will be prevented from vindicating their rights. Cases involving offering frauds, accounting misstatements, or other types of public company malfeasance are usually complex and require extensive litigation resources, multiple experts, and services that require upfront fees. For these types of claims, most shareholder investments are too small and the costs of arbitration too high to incentivize individual shareholder suits, even if the collective losses would more than justify the expense of litigation through class action. As one court put it, the realistic alternative to class action is not 17 million individual suits, but 0 individual suits, as only a lunatic or a fanatic sues for $30. Indeed, the primary defense of mandatory arbitration is that it provides cost savings to companies. But if every single member of a class sued in arbitration individually, there likely would not be great cost savings. Part of the reason that companies will save money is precisely because many investors will decide not to sue in the first place. Second, the markets will go under-policed. If we erode private rights of action, not only are shareholders uncompensated for the wrong perpetrated on them, but the wrongdoers get off scot-free. There are 2 ways to remedy wrongdoing in our markets: by governmental enforcement action or private lawsuit. Private lawsuits can be a more efficient remedy than government action in terms of investor recompense. In 2024, securities class action settlements brought by shareholders returned approximately $3.7 billion to harmed investments. By contrast, over a similar period, commission enforcement returned only $345 million to investors. This may also explain why mandatory arbitration is so appealing. Some companies would rather keep their ill-gotten gains than return them to harmed investors. If we chisel away at private actions, then we lean more heavily on the Commission to police the markets. But that crutch is faltering. The staff of the Commission have shrunk by approximately 16% since the beginning of the fiscal year, but our markets have grown. So we're reducing private enforcement mechanisms at the same time as agency resources are shrinking. One might expect that as we deregulate and seek less government intervention, we would lean more into an individual's freedom to pursue her recovery, not less. But that's apparently not the case. Third, mandatory arbitration undermines deterrence. Deterrence is subverted not only because wrongdoers are not held to account, but also because arbitration claims and awards are non-public. Parties bear the burden of compelled silence. Defrauded investors who are not part of an arbitration may not know that they've been defrauded, nor may the markets, paving the road for the same company to inexpensively engage in the same misconduct again in the future. And where there is no public account, there is also no deterrence to other would-be wrongdoers. This lack of deterrence will lead not only to more brazen misconduct, but will also reduce the integrity of our markets. It lays the groundwork for less accurate disclosures, less reliable financial statements, and executives who are incentivized to cut corners. Less accurate market information is a solution to a problem that I don't think exists. Fourth, market transparency integrity will suffer. Judicial resolution of shareholder disputes provides a public good. Arguments about the costs of litigation often leave out the tremendous benefits being provided. Private litigation allows the law to develop. Many seminal federal and state securities law cases have developed from private litigation. Where case law is allowed to develop, it provides for consistent and predictable outcomes for market participants. On the contrary, there is no consistency in arbitration. Arbitrators are often not required to follow the law. They are not bound by precedent. Arbitrators need not provide reasoning for their decisions, nor are they required to apply rules of evidence. Discovery and evidence are curbed. Judicial review is limited. This means that similarly situated investors, victims of the same mass fraud, may face significantly divergent outcomes in arbitration. That is bad for our markets, which thrive on consistency and predictability. Finally, allowing companies to mandate arbitration squelches investor choice. It's worth pointing out the dissonance in allowing companies to strip investors of the choice to litigate in court, while touting the primacy of investor choice in other contexts. For example, in the Commission's push to open the private markets to retail investors. This raises the unsavory specter that freedom of investor choice is only a Commission priority when that choice serves the goal of lining the pockets of favored business interests. All of this is to say, there are compelling reasons that mandatory arbitration provisions are against the public interest and at odds with protecting investors. They deprive shareholders of fundamental rights, fundamental choices, and they fly in the face of market integrity, fairness, and efficiency. And perhaps that is why today's action is so out of step with our agency's history. The Commission has never, either expressly or implicitly, granted permission to a public company to force their shareholders into mandatory arbitration. And chairmen and commissioners of both parties, such as Chairman Breeden, Donaldson, and Levitt, have exalted the import of private litigation alongside Congress. Before today, we have never adopted a policy of willful blindness to those provisions. To be clear, the legal analysis the staff puts forward in the policy statement does not demand the conclusion that we reach. Today's actions are a matter of policy, not a matter of law. Certainly, the Supreme Court has interpreted the scope of the Federal Arbitration Act to allow for greater enforcement of arbitration agreements. But neither the Supreme Court nor Congress has ever adjudged that the FAA requires enforcement of mandatory arbitration provisions tucked away in governance documents of public companies. And there are good reasons to believe that neither the FAA nor certain state laws would require enforcement of such provisions in the context of shareholder disputes. Absent unequivocal mandates from the courts or Congress to enforce forced arbitration provisions, the Commission should enforce the securities laws, which provide unequivocally that any attempt to require a shareholder to waive her rights is void. But perhaps the most anomalous outcome of today's policy statement is that we predetermine a certain outcome. Regardless of what a particular mandatory arbitration clause says, and regardless of our statutory obligation to make a specific public interest finding for the offerings of individual issuers, today's statement leaves little room for staff or Commission to make an assessment of whether a particular mandatory arbitration provision violates a quintessential shareholder right, which the Supreme Court has stated would be unlawful. one could imagine many clever ways that arbitration provisions could eliminate substantive rights by, for example, wholesale eliminating remedies, limitations periods, or even entire causes of action. What if there were a provision that required shareholders to bring fraud claims within 1 day of the occurrence of the fraud? We have, in effect, hardwired a finding that the mandatory arbitration is in the public interest without any real consideration of an issuer's filings. Do we even have the authority to make such a broad finding through a policy statement? I can't remember another time in recent history where the Commission chose to take a critical tool out of its toolbox for performing a task it was mandated to do by Congress. This brings me to the utter lack of input from market participants. Today's statement includes a quasi-economic analysis, which glaringly concludes, we have no idea what the outcome of our policy shift might be. There's a reason why we don't know the full extent of the costs and the benefits of today's actions. Because we didn't ask. This seismic shift has too many ramifications to be done without an economic analysis. The last time mandatory arbitration provisions took the limelight, then Chairman Jay Clayton promised that, quote, no decision would be made by the Commission absent a fair amount of consideration and debate, including input on the law, economics, and what investors want. Commissioners who came before us shared that view. Hundreds of interested stakeholders have in the past written to the Commission, expressing not only concern over greenlighting mandatory arbitration provisions, but also seeking the opportunity to be heard before the implementation of any policy change. These interested stakeholders include members of Congress, state treasurers of both parties, academics of all stripes, institutional investors, and investor advocates, among others. Indeed, one letter from 26 members of Congress summed it up well. Because of the long-standing public position, quote, because of the long-standing public position of the SEC and the significant impact such a monumental shift in policy would have on American investors, any examination of this issue should be done in a transparent manner. Anything less will be seen as a stealth attempt by the Commission to circumvent U.S. securities laws and the fundamental rights of shareholders. Today, we fail to heed this warning. Instead of soliciting public comments as to the practical, economic, and legal effects of our action, we cover our ears and simply do the thing we want to do. We could have engaged in rulemaking. We could have considered building in guardrails to protect investors and market integrity. And we could have actually addressed complex substantive questions about the nexus between our policy statement and state law, and the fiduciary duties corporate managers owe to investors. But full speed ahead, no matter the consequences. Through today's policy statement, we not only silence investors in court, we also silence their ability to be heard by the Commission, the body specifically tasked with protecting their interests. This is a double slight at best, a due process violation at worst. This also begs the question, what other consequential actions does the Commission think it can adopt without soliciting public comment? The public should be concerned, because today might mark the beginning of an era in which the Commission acts first and asks questions only later, if at all. And it would be bad enough if all the Commission did today was issue the mandatory arbitration policy statement, but we simultaneously propose amendments to our rules of practice in order to eviscerate the procedural rights of those who might choose to challenge the issuer's inclusion of mandatory arbitration. Currently, as you've heard, when either a commissioner or a third party requests Commission review of almost any staff action made pursuant to a delegated authority, those actions are automatically stayed, pending Commission consideration. This consideration is an important backstop to delegated staff action. That all goes away with today's amendments. From now on, the automatic stay, which provides the mechanism for meaningful Commission review of registration statements before an offering hits the market, vanishes. Accordingly, I also cannot support today's amendments to the Commission rules of practice. First, creating a new exception, only the third one, and the first in 30 years, to the automatic stay provisions, amplifies the tensions between Rule 431 of our rules of practice and Section 4A of the Exchange Act. Section 4A provides a statutory basis for the Commission to delegate its own authority to staff. However, by statute, the Commission must review such delegated action if one Commissioner requests review. Third parties may also petition the Commission for review of delegated actions. The statute further provides two specific, and only two specific, situations in which the delegated action, quote, shall be deemed the action of the Commission, close quote. Despite these two narrow circumstances, in which the statute deems delegated action to be Commission action, Rule 431 broadly states, an action made pursuant to delegated authority shall have the immediate effect and be deemed the action of the Commission. On its face, the expansiveness of the rule's text directly conflicts with the statute. In our legal system, that is impermissible, and the statute wins. Historically, the automatic stay provisions of Rule 431 eased that tension between the rule and Section 4A, since decisions made pursuant to delegated authority were automatically stayed once review was requested, thus halting the immediate effect of any staff action. But by removing that pressure relief valve of the automatic stay provisions, today's amendments simply amplify the conflict between Rule 431 and Section 4A. Today's amendments raise serious questions regarding whether 431 violates the Exchange Act. Second, the Commission errs yet again by deciding to enact these amendments without the benefit of public comment. We assert that today's amendments are not subject to notice and comment requirements of the Administrative Procedure Act because they qualify for an exemption for rules of the agency organization, procedure, and practice. I am not convinced that this exception applies here, since after today's amendments, an investor's right to Commission review will exist in name only. Seems to me this is more than just internal agency procedure. Even if the amendments do qualify for the exemption to notice and comment rulemaking, we still should have solicited public comment. By my count, over the last 30 years, the Commission has revised our rules of practice 17 times. And like today, we have often, though not always, asserted that revisions do not require notice and comment rulemaking. The Commission, nevertheless, solicited public comment on revisions to the rules of practice in all but 7 instances. And 6 of those 7 involved amendments that were technical, ministerial, or related to other simultaneous amendments that themselves went through notice and comment. And again, today's amendments are much more than technical or ministerial changes. Indeed, the only other time the Commission carved out exceptions to the automatic stay, it did so after notice and comment. So why not ask for comments today, when the weight of past Commission practice would dictate that we do so? Maybe the Commission views the amendments as controversial, is afraid of the comments it might receive, and is uncertain how it might effectively answer those comments. Maybe it's just in a hurry to stymie investors' access to the courts. Whatever the reason, the Commission's rush to adopt this change without input from the public is perplexing and hard to square with my colleague's past call for more robust public comment when the Commission issues rules. The Commission's decision to promulgate these consequential amendments without first hearing from the public is unsound. The amendments are also bad policy. They cut off the ability for investors to obtain any meaningful Commission review of staff decisions to accelerate the effectiveness of registration statements. Once a registration statement is declared effective, issuers can offer and sell those securities. Thus, without an automatic stay, the offers and sales might well be completed before the Commission can review staff actions. Unwinding those transactions after the fact would be much more difficult and disruptive than it would under the current automatic stay regime. In light of this, after today's amendments, the opportunity for Commission review of staff acceleration of registration statements will exist merely as an illusion. Moreover, rather than providing issuers with more predictability, stripping away the automatic stay introduces more uncertainty and a greater possibility for disruption following Commission reversal of staff action than the current automatic stay regime, which has been on the books for decades, seemingly without complaint. As such, even if the amendments were not being so transparently paired with the Commission's attempt to promote mandatory arbitration clauses, they would not merit inclusion in our rulebook. But these amendments are not traveling alone. The Commission is using them as a tool to further tilt the scales and accelerate the adoption of mandatory arbitration clauses by public companies. This will, correspondingly, supercharge our descent into a world where investors are unable to effectively vindicate the rights Congress promised them in our nation's securities laws. The Commission has decided to hastily construct a new shortcut to its preferred policy destination. Investors will be distressed to discover that the only thing waiting to greet them at the end of this journey down this new path to the courthouse is the doors welded shut. Thank you.
Thank you, Commissioner Crenshaw. Commissioner Ueda.
Well, thank you, Chairman Atkins, and for today's recommendation, but also for your remarks more broadly about capital formation and making IPOs great again. If you're forming a bandwagon to make IPOs great again, count me on board. Well, thank you to the staff from CorpFin, IM, and GC for today's presentation. Today, the Commission issues a policy statement regarding the acceleration of effectiveness of registration statements for issuers that have certain mandatory arbitration provisions and corresponding amendments to the Commission's rules of practice. For public offerings registered with the Commission, the effective date of the registration statement is of paramount importance. Section 8A of the Securities Act states that the effective date shall be either the 20th day after filing or such earlier date as the Commission may determine. Most registered offerings are declared effective by acceleration. Although during our agency's earlier history, the commissioners themselves personally voted to declare registration statements effective, that task has been long delegated to the staff. Issuers have used the acceleration provision to provide important transactional timing flexibility to consider market sentiment and economic conditions in their IPOs and other offerings. For decades, the Commission staff, acting under the direction of various SEC chairs, have taken the position that acceleration of a registration statement would not be granted for an issuer with corporate or charter or bylaw provisions requiring the adjudication of investor claims in arbitration. This policy statement is now being issued to provide instruction from the full Commission. Importantly, this policy statement does not seek to regulate the conduct of market participants, nor does it attempt to adjudicate the interplay between the Federal Arbitration Act and the federal securities laws. Instead, it focuses on the Commission's limited role as to whether there is appropriate disclosure in registration statements in deciding whether or not to grant acceleration of effectiveness. Whether there are benefits to arbitration of investor claims, such as whether they lead to lower investor costs or whether there are detriments, which have been so artfully described by Commissioner Crenshaw, is not the question that we have been tasked to answer. The federal securities laws are primarily designed so that the public has sufficient information to make informed investment decisions, rather than making qualitative regulatory judgments as to the most optimal investment characteristics. Issuers, investors, and market participants are tasked with a straightforward proposition. Do the features and characters of a proposed investment as described in the offering documents align with one's individual investment goals and risk tolerance? In issuing this policy statement, the Commission has based its position on a significant body of legal opinions of the Supreme Court of the United States regarding the FAA. This policy statement, however, recognizes that we are not the Securities and Arbitration Commission, nor are we a state, corporate, or blue sky regulator charged with merit-based evaluation of offerings. Today's policy statement describes the Commission's approach to declaring registration statements effective and does not attempt to conform behavior or express a view on whether mandatory arbitration is appropriate or beneficial for issuers or investors. More importantly, it places focus on the adequacy of disclosure as being the central consideration on declaring registration statements effective. In tandem with this policy statement, we are amending the rules of practice relating to procedures governing commission review of staff actions made pursuant to delegated authority in connection with the determination of the effective dates of registration statements and post-effective amendments, and the determination of these dates and times of qualification on an offering statement and post-qualification amendment under Regulation A. These amendments reflect the fact that an automatic stay of the staff's determination to accelerate effectiveness or to qualify an offering statement after sales have commenced would be highly disruptive to the distribution process. Today's amendments will remove the unpredictability resulting from an automatic stay. More importantly, a key safeguard remains in place, the issuance of a stop order under Section 8D of the Securities Act. The Commission remains, as always, vigilant as to frauds perpetrated upon investors and will use all available regulatory tools to address securities fraud involving registered offerings. So I thank the staff in the Division of Corporation Finance, the Division of Investment Management, the Division of Economic and Risk Analysis, and the Office of General Counsel on these matters. I also join in thanking Cicely Lamoth for her service as Acting Director of the Division of Corporation Finance for the past 10 months, and I guess the clock is still ticking on that a little bit. But I do remember when you came up in December and we had a chat about becoming the Acting Director, and I think the taxpayers have received a tremendous amount of value for fulfilling the roles of not only Director, but Deputy Director of the Disclosure Review Program. And so for your leadership, your always pleasant nature, I really thank you very much for that. And I know, I think you'll be happy to go back to your normal day job, but really it's just been a terrific period while you've been at the helm. And I should add, at the table right now, we also have an acting director, chief economist, and an acting general counsel, both of you who assumed those roles in January. This agency could not have been as far advanced without Jeff and Rob, without your efforts to make sure that this agency quickly pivoted to the direction of making the capital markets great again and to get this agency on the right course. With respect to this policy statement, we just heard a fair number of potential really bad outcomes if mandatory arbitration occurs. But right now, we essentially have somewhat of a policy in that staff have advised issuers who seek to have a registration declared effective that the staff would be unlikely to be able to grant that acceleration if that mandatory arbitration provision remained in place. Is that correct?
Thank you for that question. So I think that there has been, the staff, of course, is always reticent to get in front of the commission. I think, as we noted in the release, the commission has not stated their formal policy on the views related to mandatory arbitration. And so in situations where we have had questions about what would happen if a mandatory arbitration provision was included, the staff has indicated that we would consider whether that should be considered by the commission instead of us exercising our delegated authority. But we have not declined someone's acceleration request to go effective with the mandatory arbitration provision.
All right, well, I appreciate that. But from a practical standpoint, if someone is in the middle of doing an IPO, market conditions can be up and down, timing is of importance, there would be some sort of time lag between getting commission approval should they want to seek, the issuer to seek that. Wouldn't that be right?
Yes, so I think while we have not actually denied an acceleration request, I think your point that the timing that an issuer requests acceleration is often tied to market conditions. So the inability to predict with some level of certainty as to what would be the path forward for acceleration has impacted whether issuers have chosen to continue to move forward with the mandatory arbitration provision. So again, while we've not declined to accelerate, we do understand that some issuers have thought that to include the mandatory arbitration provision, they may find that uncertainty surrounding, their path to acceleration, whether it will be done in the normal course by the staff or whether that would be considered by the commission. That potential impact on timing is such that they would just choose not to include the provision.
Yeah, and I appreciate that the staff's thought that this really is a commission decision, but from a reality of if you are going to market on an IPO, that is something that you just, in terms of their own cost-benefit analysis, putting off an IPO until you get that go-ahead from the commission, which is really at the discretion of the commission as to pick that up, could render the economics of doing the IPO impractical. So I think it's very important that we establish what we think of this position is. Now, we could have perhaps put a statement that says the exact opposite, that we would not declare effective. So I'm going to turn to GC right now. If we had taken that position, said we refuse to allow acceleration by effectiveness, and that essentially means you, for all practical purposes, you can't do an IPO. One of the important pieces when you do an IPO is the pricing amendment. Our rules allow the precise, we'll do an offering range pre-effectiveness that will allow the issuer to file it with the final price subsequently under Rule 430A to omit certain information, with the final price being in a post-effectiveness supplement. But we only allow that if it's accelerated. So if we were to adopt a policy that we would not exercise or we would direct the staff to say acceleration would be not approved either by the commission or the staff, do we think that, and that was about the commission, that there might be litigation challenges before the courts if they said this isn't consistent with the Federal Arbitration Act and Supreme Court precedent?
Commissioner, presumably the basis for taking such a position would be that we thought the mandatory arbitration provision was inconsistent with the public interest finding that the commission or the staff by delegated action has to make when accelerating a registration statement. As is explained in the release, given where the Supreme Court precedent is and how they've said that there is no conflict between the Federal Arbitration Act's policy favoring enforceability of arbitration provisions and the federal securities laws, we do not think there would be a basis to object on the public interest grounds for accelerating registration.
Yeah, no, I would share that concern that we would not have a basis for that. And should we as a commission have voted to take the opposite position we're taking here, in fact, that we would deny mandatory acceleration if there was a mandatory arbitration provision there, I think we would be challenged in the courts, and this would result in yet another black eye and litigation loss for the SEC. And yet at the same time, I think this effectively making it very, very challenging to ever have a commission decision is one where it never gives anyone the right to, in essence, ask the commission for a decision. And then when we make our decision, I fully acknowledge that people who don't like us will have their day to challenge us in the appropriate forum, court, or could be mandatory arbitration, but challenge us on the legality of our position on this. With respect to the, if you look at the acceleration requirement, it does say that we have to make a public interest and protection of investors finding in granting the acceleration or Section 8A. Do we believe that somehow makes us a merit regulator equivalent to the same authority that, say, a state blue sky regulator has to opine on the merits of an offering? That it basically makes the disclosure part really not the central, but it really is a merit standard.
Commissioner, I think the way I would answer that is to say that the courts have considered the public interest standard in the context of the federal securities laws and other federal statutes. And what the courts have told us is that in applying those standards, they need to be applied with an understanding of the purposes of the statute, which are applying, and it's not permissible to consider factors that the agency doesn't have authority to regulate. And so in applying that standard, we would focus on sort of what our primary authorities are under the Securities Act, which is, as you say, primarily focused on making sure there's complete and adequate disclosure.
Oh, I completely agree with that view, so thank you for that. I mean, otherwise, I just think it really opens up a really big set of uncertainty as to what our authorities is. We can engage, if you're a gun company seeking to raise capital, we say, we don't like gun companies, so we find it not in the public interest. If we find food or sometimes of manufacturers, we don't like you, so we're not going to find it in the public interest. We think you have too high of scope 3 emissions. That's not in the public interest. And I just think that if we were to have a very broad view of what it means public interest and protection of investors without reading it really in the context of the whole statutory framework, that just creates a sort of a Pandora's box of the commission getting into the merits of an offering, which is, at least the way I look at the securities law, is not what Congress instructed us to do. We are a disclosure. It is a disclosure regime. We rely on investors to make those decisions, and market participants. If they don't like the provisions, their simplest choice or provisions and attributes of an offering, their simplest choice is not to buy. Thank you. I don't have any further questions.
Well, thank you, Commissioner Ueda. So I did want to follow up on a few things here, if I could engage in a little dialogue with you all. One thing I just state, I think one problem is that this commission or the agency over the last 4 years actually did just that, disfavored industries or lines of business were, basically the IPOs were effectively strangled, in the crib or slow walked until they just kind of disappeared. So that legacy lives on, unfortunately, in the marketplace where people, who lived through that, remember it very well. So that's why I think this is such an important action for transparency, actually, and to go forward and turn the page on that pretty sordid history. One thing I wanted to maybe engage in just a thought experiment here, and not to opine on state law, but first, Delaware this year, adopted this amendment to the general corporation law of their state, where they basically effectively said no to close the door to, at least in my reading of it, mandatory arbitration. Maybe that'll be different once the Delaware courts start to maybe interpret it. But if you have a state that where it's been silent before and then comes up with something that says no or says yes, and in this case says no, does that imply, do you think, that it was okay in previous, if it was silent, if the law was silent? Does that, leaving everything else out, does that imply that it would have been okay before to have mandatory arbitration in a corporate bylaw context?
Chairman Atkins, I think the question of corporate bylaws and whether or not they represent binding written agreements for purposes of the FAA gets into a complicated area that's at the intersection of the FAA, which is a statute we don't administer, and state law. And so I think one of the points that we make in the policy statement is that the commission and the staff is not well positioned to make those sorts of determinations. And we do acknowledge that I think there's been debate about sort of the bylaw provisions and whether or not they should be considered contractual provisions. Again, we don't think that's the role of the SEC to weigh in on those matters. And because we're not really well positioned to resolve that, the policy statement indicates that the approach the staff intends to take is to look for adequate disclosure of those issues if a company were to include one of these provisions.
Great, right. So even though Delaware does something and other states either are silent in that regard or openly permit it, then it comes down to the choice of the actual jurisdiction for companies and shareholders and whatever.
That's right, and I'll defer to my colleagues in Corp Fin, but I think in either case, we would be looking for a disclosure.
Yes, that's correct. The staff, of course, could consider the fact that a certain state may have a particular law that would be different in that regard. However, whether our focus would then be to get disclosure in the registration statement related to what the possible enforceability provisions are and the impact to investors who may choose to invest in that particular entity.
Right. So let's take an analog to all of this because we're focusing very broadly. If we look at, we have a concept release out on this, and so we're looking for comment on that regarding foreign private issuers. So they come in all stripes and shapes and sizes and whatnot, and organic corporate law of the various jurisdictions obviously varies pretty broadly. So some jurisdictions have loser pays, with respect to, lawsuits against, in their jurisdiction, and particularly in this case against corporations by shareholders or by whomever. In fact, there was a Delaware Supreme Court case just on that issue back about 10 years ago that subsequently the legislature in Delaware seems to have overruled. But so that's fee shifting with foreign private issuers, which is there. And then we have variable interest entities and, from China and whatnot. So do we forbid any of those sorts of things or deny acceleration, if they come to enter our markets?
So, no. I think in the situation where there are some concerns or disclosure items where an investor may have an interest in that information, and whether it's material or not, we would focus on getting adequate disclosure of what those risks are in the registration statement. So that would be mandatory arbitration, or it could be a situation where there is a CBI with the VIE that may pose a certain or different risk. But that would not necessarily, again, I think going to what Bryant mentioned earlier, which is the scope of our public interest finding and how we evaluate that is within federal securities laws, and that's going to be based on a focus on disclosure and making sure investors have that information, and then they can then choose what they would like to do.
Right. But we've never effectively shut the door on somebody without, to your knowledge, I guess, in those contexts.
To my knowledge, we have not declined acceleration of a registration statement for those items.
And then I guess with our authority, if we, further to what Commissioner Ueda was saying, if we decided that, that mandatory arbitration that's allowed by a state, if we decided that, that that's just beyond the pale and we wouldn't consider any registration statements of companies that have that sort of thing. Is that within our authority, do you think? Because I guess, the case back from 1990, Business Roundtable versus SEC, where the DC Circuit basically said, keep your fingers out of state corporate law. That's not your jurisdiction. This inherently, I would argue, is state corporate law, and particularly if a state either allows it or doesn't. Is that a good way to look at this?
That's correct, Chairman, and I think it is the Business Roundtable decision that we were thinking of when we said it would be difficult to object to taking a registration statement effective on the basis of a public interest basis in light of sort of where the Supreme Court has come out in terms of the interaction between the FAA and the federal securities laws.
Right. And to quote from the BRT, and you have this in a footnote in your very well put together document here, but that they overruled the one share, one vote rule of the commission because it would overturn or at least impinge severely on the tradition of state regulation of corporate law. So that's about as clear a statement as I can think of. Okay, thanks on that. And then when we look at the history of, how this give and take with the marketplaces being, I guess, back to the transparency, I think, we're being very transparent today in addressing this and to try to clear up, years of ambiguity that basically, in my view, reeks of arbitrary and capricious actions, frankly, by the agency, and basically no recourse just because of the dynamics of the marketplace for somebody who feels aggrieved and it's not commission action. There's really nothing that you can do. You're just kind of out there and banging your head against the wall. So I think our being transparent about this today and acknowledging that we don't have authority in this area, I think is at least in my mind, a good way to approach it, and ending this sort of ad hoc secretive type of way where I like to say only the priesthood of the anointed really knows. So since we haven't, I guess going back to the question I was leading to, has there ever been any statement by the commission regarding arbitration? I mean, you cite one in 1986 in the amicus brief. And so as far as what we did in what the commission did in that, amicus, what was do you recall the facts of that and what the commission said?
That was the McMahon case, I believe you're referring to, Chairman Atkins, and that had to do with a mandatory arbitration provision between a broker and its customers, but it did review and analyze sort of whether or not that mandatory arbitration provision was inconsistent with the anti-waiver provision. Right.
And so that was back in the John Shad Commission era. So anyway, and so basically the commission said that, the mandatory arbitration provisions and broker agreements, are okay, basically upheld those. Or on the side of it. I mean, we didn't obviously rule in that, we advocated that to the court.
Yeah, I believe in the original litigation, the commission filed an amicus brief saying that it was supportive of, or at least did not object to the mandatory arbitration provisions in the context of the broker-dealers and their customers. And the commission pointed to the fact that we have oversight authority over the broker-dealers. I believe it did indicate that it would have concerns about mandatory arbitration in the issuer-investor context. Subsequently, of course, the court in McMahon found that there was no conflict with the anti-waiver provisions. And in the subsequent cases that have come out, no court has looked to that sort of oversight rationale as a reason why it would change its views about there being no inconsistency with the anti-waiver provisions.
Right. Okay. And then, I guess as far as, what we're doing today then, could be characterized as, with all these precedents and whatnot, as deferring to state law, I guess is the way I would look at it. Is that a good way? Do you agree? Or?
As I mentioned before, I think there are some complicated questions about whether if a state sought to limit or restrict arbitration, about whether that's preempted by the Federal Arbitration Act. I think we're neither experts on state law nor do we administer the FAA, so that's not a matter in our view, for the staff or the commission to resolve. It would be a matter probably for the courts ultimately to resolve.
Good. So even though Delaware takes one view, Texas, Nevada, North Carolina, and others can do the same, do opposite, so we can see how that shakes out, in the crucible of innovation that is the glory of our federal system. So anyway, all right. Well, I think thank you very much for your input here. Are there any other questions or points that you all want to make? Nope. Okay. So so we're, as I mentioned before, we'll have 2 votes. So do the commissioners vote to approve the Division of Corporation Finances recommendation to issue the policy statement regarding acceleration of effectiveness of the registration statements of issuers with certain mandatory arbitration provisions?
Yes.
No.
Yes.
And yes. Thank you very much. So that's 3-1 for the Secretary's benefit. Do the commissioners vote to approve the Division of Corporation Finances recommendation to amend Rule 431 of the Commission's Rules of Practice?
Yes.
No.
Yes.
And yes. So thank you very much. So that concludes the business on today's agenda, and the meeting is adjourned. Thank you.